Hi, I'm Ross Pitcoff of the Pitcoff Law Group, located in New York City. The purpose of this channel is to assist business owners and to help them navigate the complex landscape of commercial litigation, whether they have a dispute with a partner, a shareholder, or a third party. And now, let's move on to Preliminary Injunctions 101. Should you look to obtain a preliminary injunction for your business-oriented litigation to be filed in state or federal court? In this video, I'm going to share with you what a preliminary injunction is, how you can obtain one, how it works, and what the benefits are. By the end of this video, you should be armed with a much better idea as to whether or not it makes sense for you to obtain a preliminary injunction for your business-oriented dispute. A preliminary injunction is a form of a pretrial court order, otherwise known as equitable relief, that stops a party from doing something during the pendency of a litigation. In order to obtain a preliminary injunction, the most important thing a party must show is that, absent the relief sought being granted, there would be irreparable harm to the plaintiff, meaning that if this case were to continue without this special equitable relief being granted in the interim, then any judgment obtained by the plaintiff at the end of the litigation could be rendered worthless. The way the preliminary injunction order works is that once you obtain a preliminary injunction, it needs to be served on the opposing party. Once you serve the order on the opposing party and you file an affidavit of service with the court, the defendant is then precluded from taking any action which the order states he, she, or the company cannot take in the underlying judgment. Now, at that point in time, if the defendant does breach the order, then you can move for contempt. And there are two types of contempt. One is known as civil contempt, which means that the defendant could be liable for monetary damages for their willful breach of an order. Or number two, there's also criminal contempt, which is much harder to obtain, but it happens in a scenario where there's an egregious violation of a preliminary injunction order, meaning that the defendant might even be issued a warrant for his or her arrest. There are three key elements that every plaintiff must show if they would like to seek a preliminary injunction and obtain one before a court. Number one, the plaintiff must show that there's a likelihood of success on the merits of their claims. Number two, the plaintiff needs to show irreparable harm. Number three, the plaintiff needs to show that a balancing of equities is in their favor. And number four, the plaintiff will often argue or should argue that they should not be required to post bond even if their preliminary injunction order is granted. Now, most of the time, if you're getting an injunction, it usually means you're going to have to post bond, but it always makes sense to make the argument as to why you should not have to. And now, let's dive into the details of those elements so that we can see how we can establish and obtain a preliminary injunction. To establish a likelihood of success on the merits of claims, the plaintiff needs to first set forth theories that they're trying to prove and intend to prove at trial. So, for example, the plaintiff will set forth all of the elements required to establish a claim for fraud, a claim for breaches of fiduciary duties, a claim for corporate waste, claims for unjust enrichment, etc., etc. The next step is the plaintiff will then perform a factual analysis and tie facts to those legal claims so that they can show that there's a high likelihood they'll be able to satisfy those elements at trial. Now, in addition to the facts and in addition to the legal theories, the plaintiff will then want to use a lot of documentary evidence and support to show that there's actual proof to justify why it is they're seeking the relief that they're seeking. Emails, contracts, bank statements, anything that you can show to the court that will show that there's a high likelihood that the allegations you're claiming happened actually did. You'll also want to have credible witnesses through the forms of affidavits. Affidavits are sworn statements by witnesses who can attest to what's transpired. Beyond that, you're also going to want to utilize case law. Case law is a means by which you're citing various cases of the law that show that based on everything that's taken place, you believe that you'd likely win in an outcome of these matters. Irreparable harm is the most significant of all the elements you're going to be required to establish to obtain a preliminary injunction. And that is because you need to show to the court in an emergency manner, if the court does not grant the relief you're seeking, then there's going to be imminent damage that is more than simply a financial loss. And what do I mean by that? If you're seeking to sue somebody because they failed to pay a lender back you as the lender on a promissory note, then your ultimate award is monetary damages only. Preliminary injunctions cannot and will not attach when the relief sought is simply a monetary damage. But if there's something else involved, something tangible, assets, property, that's a different story. For example, if a defendant is trying to sell shares that belong to you in a company, you might be able to get an injunction. If a defendant and a bad faith actor is depleting the company bank account or diverting company assets to a third-party company, you might be able to get an injunction. Confidential information, trade secrets of the company. If somebody's threatening to expose that information, or if they're doing that and you need to enjoin them from doing it further, that would be a justification to obtain a preliminary injunction. And because of this emergency nature of these types of applications to the court, it's essential that you come forward with documentary proof, you come forward with clarity concerning the relief you're seeking, the justification and causation for why it's needed. Otherwise, a court is unlikely to grant this type of emergency relief. The third element you need to establish is to show that a balancing of equities is in the favor of the plaintiff. In those situations, the court is going to consider the potential damage to the plaintiff if the relief is not granted, as compared to the potential damage to the defendant if the relief is granted. In those types of situations, it's very important to show why the aggrieved party, you as the plaintiff, will suffer significant damages that are well above and beyond the potential damage to the defendant if this relief is granted. Now, bond is a form of collateral whereby the court requires the plaintiff to post it so that in the event that at the end of the litigation, after it goes to trial, it's determined that the injunction actually should not have been granted in the first place, the defendant has a mechanism and means of recovering monetary damages. Oftentimes, court will require a plaintiff to post bond as part of their application to obtain a preliminary injunction. However, there are circumstances, which again are determined on a case-by-case basis, where a court will actually allow the plaintiff to obtain an injunction and will not require that plaintiff to post bond. Therefore, it is always suggested that you make the argument as to why bond should not have to be posted as part of the plaintiff's application. The benefit of obtaining a preliminary injunction is that a defendant will be estopped and enjoined from otherwise participating in deleterious conduct that would harm your business pending the outcome of your litigation. For example, the defendant could be restrained from taking money out of the company bank account, or the defendants can be estopped from trying to transfer assets away from the business. The detriments are that it is a costly endeavor, and the courts are likely to require that you post bond, which is a form of collateral, to ensure that if at the end of the litigation it turns out that the injunction shouldn't have been granted, the defendant will have some sort of mechanism to recover their losses. Challenging, I know, and that's why it's important that you speak with an attorney prior to initiating an action and seeking injunctive relief. You obtain a preliminary injunction by filing what's called an order to show cause, along with supporting papers, such as a memorandum of law in support, emergency affidavits in support, an affirmation in support, and similar information to show the court why it is you need this special type of emergency relief. The benefit of filing this type of relief, which is filed in conjunction with your complaint or summons with notice, is that if you get the relief, the defendant will be precluded from doing the detrimental conduct until the end of the litigation. The detriment is there is a cost to this, and it is a costly endeavor to file for a preliminary injunction at the beginning of the litigation. Therefore, a cost-effect analysis has to be determined as to whether or not it makes sense to actually go ahead with this type of filing. We went through a lot of information in a short period of time. If you have any questions, please make sure to subscribe to the page, to like the page, and then to leave your question in the comment section below. We'll seek to make future video content based upon the comments that we see, and we'll also be leaving free sources in the links below. And if you know of anybody that might benefit from this video, it's easy. Just forward them the video, or you can share our page with them.